Hello everyone, welcome to the US Immigration. If you thought birthright citizenship in the United States was settled law, what's happening right now in Washington may feel like a shockwave in 2025. The topic of birthright citizenship, the constitutional guarantee that anyone born on US soil becomes a citizen, has moved from history books and civics classes into front-page headlines, legal battles, and for many families, serious uncertainty about their children's future. What you're seeing isn't just another news cycle. It's potentially one of the most significant constitutional and immigration controversies in decades, and it directly affects millions of people here at home and around the world. In this video, we're going to break down what's happened so far, why the events of 2025 carry such major consequences, and crucially, what this means for you and your family, not in abstract terms, but in practical, understandable language. This is about people's lives, their identities, their rights, and in many cases, their children. And because this story continues to evolve, we'll also look at what might happen next, and what you should pay attention to in the coming months. At its core, birthright citizenship in the United States comes from the 14th Amendment to the Constitution ratified in 1868. It states that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. That principle, known as jus soli, or right of the soil, has meant that a child born here, regardless of their parents' immigration status, is automatically a U.S. citizen, with all the rights and protections that citizenship entails. This broad interpretation has stood for more than 125 years, including surviving a key Supreme Court decision in 1898 in United States versus Wong Kim Ark, upholding birthright citizenship for the children of non-citizen parents. Yet in January 2025, on the very first day of his term, President Donald Trump signed Executive Order 14,160, titled Protecting the Meaning and Value of American Citizenship. This order sought to fundamentally change how the government interprets the citizenship clause of the 14th Amendment. Under the order, automatic citizenship at birth would no longer apply to children born in the United States to parents who are either in the country unlawfully or in the country temporarily, for example, on student, work, or tourist visas or without any lawful status. If it had taken effect, this policy would have meant that only children born to at least one parent who was either a U.S. citizen, a national, or a lawful permanent resident at the time of birth would automatically become U.S. citizens. In practice, this would exclude the U.S.-born children of many immigrant students, temporary workers, and undocumented residents. The legal and human implications of such a change are enormous, affecting healthcare, access, education rights, travel, employment, and the fundamental sense of belonging for families across the country. But for now, it's important to make one thing clear. Executive Order 14,160 is currently not being enforced. Multiple lawsuits were filed almost immediately after it was signed, challenging the order as unconstitutional under the 14th Amendment and in violation of long-standing legal precedent. Federal courts across the country issued preliminary injunctions blocking enforcement of the order, citing strong constitutional questions about whether the president has the authority to override birthright citizenship guaranteed by the Constitution. Those litigation battles culminated in several related cases that made their way toward the Supreme Court in 2025. In a case consolidated under Trump versus CASA, the Supreme Court issued a controversial decision in June 2025, limiting the court's ability to issue universal nationwide injunctions that prevent the government from enforcing the order broadly. Instead, the High Court held that courts should generally tailor injunctions only to the specific plaintiffs in a case. A procedural ruling that did not resolve the constitutional questions directly, but that had the effect of complicating how lower court blocks on the executive order were applied. At the same time, class action lawsuits such as Trump versus Barbara have sought preliminary injunctions specifically on behalf of children who would be affected by the order, arguing that such a sweeping change to citizenship rights cannot be implemented without violating the Constitution. In July 2025, a federal judge granted such a class-wide injunction, blocking enforcement of the order for those covered by the lawsuit. Then, in December, the legal landscape shifted again when the U.S. Supreme Court agreed to review the constitutionality of the Birthright Citizenship Executive Order as part of its 2025 to 2026 term. This means the High Court will weigh arguments about whether the government can legally limit or redefine birthright citizenship, with oral arguments expected in early 2026 and a ruling anticipated as early as summer 2026. That timeline, potentially a Supreme Court decision in mid-2026, is critical. It means that for the next several months, the legal status quo remains in place. Birthright citizenship continues to be recognized under existing law and constitutional interpretation, and the executive order cannot be enforced while injunctions remain effective. But it also means that the ultimate answer is not yet settled, and major change could come depending on how the court interprets the Constitution, particularly the meaning of the phrase "subject to the jurisdiction thereof." So, what are the consequences of all this right now and, in the months ahead? First, birthright citizenship is not currently being taken away. Children born in the United States today remain U.S. citizens under long-standing constitutional interpretation. That foundational principle is still in effect as litigation continues. But because the executive order remains part of federal policy, and because the Supreme Court has agreed to review its legality, there is a degree of uncertainty that affects immigrant families, legal practitioners, and policymakers alike. Second, even the possibility of a future ruling upholding restrictions on birthright citizenship could have pretty profound ripple effects. Citizenship is not just a legal status. It's tied to access to education, federal benefits, voting rights once age eligible, travel documents like passports, and protection under U.S. law. Should the court eventually uphold limits on citizenship at birth, subsequent litigation and legislative action would be inevitable to define who qualifies and what rights are guaranteed. That could really reshape the landscape for children born to non-citizen parents, including families who expected automatic citizenship and whose futures are built around that expectation. Third, the controversies around this issue are already influencing public discourse and individual decision-making. Some families are exploring dual citizenship pathways. Others are contacting legal counsel to understand how changes might affect their children's status or documentation. Even native-born Americans have reported increased interest in alternative citizenship options as political and legal uncertainty grows. At the same time, there are practical legal safeguards in place right now. Lower court injunctions continue to block enforcement of Executive Order 14,160, meaning that until the Supreme Court issues a definitive ruling, the order cannot be implemented. People seeking clarity should rely on official court decisions, Supreme Court announcements and guidance from qualified immigration attorneys or accredited representatives rather than social media speculation or informal commentary. If a future decision upholds the executive order's restrictions, the implications would extend far beyond the immediate legal question. It could prompt Congress to act either to protect birthright citizenship through statute or to create new legislative frameworks for defining citizenship at birth. It could also spark additional litigation over how citizenship is documented, how state and federal agencies issue birth certificates and passports, and how civil rights law interacts with nationality law. All of these processes take time and would involve another cycle of interpretation, challenge, and implementation. For families who currently have newborns, expectant parents, or children approaching adulthood, staying informed is essential. Keep track of Supreme Court schedules, official releases from the court, and relevant agencies, and updates from trusted legal experts. If you have questions about your specific situation, reach out to a licensed attorney or accredited representative, particularly if you are navigating related immigration processes such as residency, naturalization, or visa adjustments. Above all, it's important to understand that legal processes often move slowly and unpredictably, especially when constitutional questions are involved. A Supreme Court review does not always produce immediate change. Sometimes it clarifies legal standards without overturning existing protections. Regardless of the final outcome, being prepared with accurate information and realistic expectations is the most effective way to navigate this moment. Breaking news can feel disorienting, especially when it touches something as personal as citizenship and family identity. But, history shows that rights enshrined in the Constitution, especially those as fundamental as birthright citizenship, have really deep roots in American law and civic tradition. How the Supreme Court interprets those roots in the context of modern immigration policy will honestly shape not just legal doctrine, but real lives. As this story develops toward oral arguments and possibly a ruling in 2026, it's important to stay grounded in what is confirmed, to be cautious about what is speculative, and to stay proactive about seeking reliable guidance. You deserve clarity, and having a clear understanding of both the legal landscape and your own options is the best way to protect your family's future. That's where we leave it for now. Birthright citizenship remains protected under existing law, but 2025 has brought this century-old principle into sharp legal focus. What happens next will matter, not just in courtrooms and state capitals, but in homes and communities across the country. That's all we have for this bulletin. The U.S. Immigration Hub channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas such as B1 and B2, work visas such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family